Today the majesty of the Supreme Court is fixed within the fabric of our nation. It works as a bulwark with the executive and legislative branches against the daily passions which would stampede us into irretrievable harm. It has not always been thus. During the administration of Washington and Adams, the court's relationship to the other two branches was ill-defined. Only good Federalists were selected for appointment, and the cases that appeared before it did not call for the court to interpret its relationship and the rule of law with the other two branches. In 1801, that changed. The newly elected president and Republican majorities in Congress moved promptly to rescind legislation creating a number of new judgeships that President Adams filled in the waning days of his administration. In a few cases, appointments duly made had not been delivered prior to President Jefferson's taking office. One such appointment, William Marbury's, steered the court into the course it now comfortably assumes as the arbiter of the Constitution. This case first tested the limits of both executive power and congressional authority, and moreover affirmed the court as the arbitrator of constitutional disputes. Marbury was a trustworthy and staunch Adams Federalist. His reward was to be appointed Justice of the Peace for Georgetown. Though the appointment made it through the hoops of Senate consent and signature by the outgoing Secretary of State, it was not delivered prior to the appointment of James Madison as Secretary of State in Thomas Jefferson's administration. Madison refused to deliver the signed and sealed appointment. Marbury, faced with Madison's refusal, filed under the Judiciary's Act of 1789 in the Supreme Court for an order that would require its delivery. In the opinion of the court on Marbury's request, Chief Justice Marshall carefully set out the origins and limitations of congressional power, and in measured prose established the paramount power of the Constitution and the court's role as its interpreter, including the right to declare an act of Congress unconstitutional. As it pertained to William Marbury's, Justice Marshall found that the Judiciary Act exceeded Congress's constitutional authority to hear a case such as Marbury's as a court of first review. By resisting an expansive notion not found in the Constitution, by chiding a prior Congress, a Federalist Congress at that, for exceeding its authority, and the executive branch for exceeding its authority and not carrying out its responsibilities under the law to deliver this appointment, Marshall established the authority of the court, but dodged a confrontation over the appointment by dismissing the case as improperly brought. When regarding the opinions today, its wisdom and clarity of thought strike us. Chief Justice Marshall assumes the Delphic robes of the ideal justice in his restrained assertion of the court's jurisdiction. His appointer, John Adams, in what is oft listed still as the description of the ideal justice, called for men of experience on the law, of exemplary morals, invincible application, unruffled calmness, indefatigable application, and subservient to none. Regardless of party affiliation, we depart from that test at our peril. When justices do not act with judicial restraint in picking cases and the issues to be decided, they become legislators. By issuing ruling on expansive notions nowhere found in the Constitution, we make a legislature of our courts, destroying the balance among the branches required to make our system work.